So we have a little technical problem, but it will not prevent us from getting started. So today we will be looking at two topics. We will still spend 1 hour related to subversive speech. And then we will change topics and we will talk for the second hour about defamation. It's a classic free speech problem. The conflict between, on the one hand, freedom of expression, on the other hand, reputation, and we will see how this conflict is tackled in different jurisdictions. What we will also do today in the first hour, I will give you a bit more background about the United Kingdom and its constitutional system, because I would say, as with the United States, we saw also there are some specificities when it comes to free speech. Here it's more the constitutional setting as a whole, which I think also has an influence how far courts go when they assess acts of parliament. I think we have someone from the UK here, right? So you feel free to step in, take over, as long as we're having, till we solve also this technical issue. Maybe just when we look at the United Kingdom, one specific feature when we talk about constitutional law is that there is no written constitution. You will not find a document named constitution, and a document which also a second characteristic would be that you have no entrenched acts. You know what I mean by entrenched? So basically what is typical of a constitution is, as was said by the US Supreme Court, it's not changeable by ordinary means. It's generally harder to change a constitution than it is to change acts of parliament. In Switzerland, you would have, for example, for a constitutional amendment, you need a mandatory referendum, you need the majority of the cantons and the majority of the people. So constitutions can be then more or less hard to change. The US Constitution is extremely difficult to change, very few amendments, but a specific characteristic is that they will be basically harder to change than ordinary statutes. So in the UK, you don't have a document called constitution, and you don't have any acts of parliament which would be harder to change than ordinary acts. At least politically speaking, yes, but legally speaking, there's only basically acts of parliament and nothing above. In Swiss constitutional law, we also talk about the substantive constitution, so saying the formal constitution is the entrenched document. Obviously, every state has what we call a substantive constitution, in the sense that there are principles and fundamental rules which will govern and structure the polity. So in that sense, the UK has obviously also a substantive or material constitution, but which is, I would say, composed of written and unwritten rules. And very important is this principle of sovereignty of parliament, which I would say is like a bedrock principle of the whole constitutional order, and which explains, I will return to that, that there is no entrenched document. About the constitution, you have a slide, maybe some of you have them, can look at them, have them in front of eyesight, is a quote by Dicey, describes it quite well. Our constitution, in short, is a judge-made constitution. Merci beaucoup. And it bears on its face all the features, good and bad, of judge-made law. So I would say nowadays the constitution in the UK is not just judge-made law, but it has these common law features. There's also different acts of parliament and other unwritten sources. When we look at these different sources, so there are unwritten sources. The common law would be the judge-made law, but there's also conventions, royal prerogative. Has anyone got an idea what that is? Or otherwise I can draw on our UK expert if you want to step in, I don't know. What would conventions be, for example, or royal prerogative, any idea? It's hard to be called an expert on your own jurisdictions. So you refer to, you said, decisions taken by the royals. So basically, I would say it may come close a bit to what we call also customary law, that traditionally, I mean, the UK was more as a monarchy which evolved towards a towards a parliamentary democracy where the king, the queen still retain some traditional powers. Nowadays they are rather formal, but still, for example, it's for example the prerogative of the king or the queen to dissolve parliament. She has to take the decision to grant, for example, honors. You see that often in films, granting of honors. And also she would recognize, or he would recognize, foreign states. So you have certain powers traditionally still exercised by the king or the queen. It's written nowhere. So it's more from tradition, and conventions are in a way comes close to customary law, so it's also rules which have a long tradition, but they are considered actually political rules, but they are always followed, or they are considered as mandatory. To give you an example, the whole idea that the government is responsible in front of parliament is a convention. You will not find an act saying, well, there can be something like a vote of no confidence or so. Or the convention that the prime minister will be the leader of the party which won the election. So it's really fundamental rules of the whole political system, but they are not found in written laws. I wonder if you couldn't get some light in here, no? It's just, I feel like going to sleep, but it's maybe not a good idea. Sorry. Wait, I find it not here at like in deep, but maybe it's my sensitivity today to being in the dark. Then you have written sources. Sometimes you will find in UK textbooks also the words constitutional statutes. But careful, these constitutional statutes, they are ordinary, legally speaking, ordinary acts of parliament. They are not harder to change than acts of parliament. Okay, we let this noise vanish. Why are they called constitutional statutes? It's basically because of their importance for the whole constitutional system. I have listed a few here. For example, maybe I will start at the bottom with the most recent. The Constitutional Reform Act is the act which created the UK Supreme Court. Before, the highest judiciary was a section of Parliament, actually, was a section of the House of Lords, which at some point appeared quite weird in the light of separation of powers. We will look at the Human Rights Act today. It's the act which incorporates the European Convention into the UK legal system. Also very important, you have special acts about protecting against discrimination. And the Devolution Act, the UK used to be more of a centralized state and then started decentralizing, giving powers to Scotland, Wales, and to Northern Ireland. They all have not the same degree of power, it's asymmetrical as a system. And now I think that shows quite nicely, it's hard to imagine now that Westminster would do away, would just abolish the Devolution Acts, but I mean, legally speaking, Parliament could do that. It's an ordinary act of Parliament. The European Communities Act, not very relevant anymore after Brexit, but it was, for example, the act which also said that EU law trumps UK law. And I remember I had classes in Cambridge with a professor who had at the time been in the diplomatic service, and he made us read the provision. No one understood anything. And he said, well, actually, we disguise supremacy of UK law in a way to make sure Parliament doesn't notice it. So that's a little anecdote how you get things past Parliament. But you see the idea, acts of Parliament, which would politically be very hard to abolish, but legally speaking, it's not impossible. And you do hear every once in a while proposals that particularly the Human Rights Act should be abolished, etc. Then a few words about parliamentary sovereignty, which is really like a bedrock principle of the UK constitutional order, again a quotation from Dicing, where he basically lists 3 traits of sovereignty of Parliament. First, the power of the legislature to alter any law, fundamental or otherwise, as freely and in the same manner as other laws. So that's this very idea you can't have entrenched acts. You can't have a formal constitution above acts of parliament, which would be harder to change than ordinary acts of parliament, and independently on how important the content is. Secondly, and that follows from the first trait, you don't have a distinction between laws, acts of parliament, and constitutional laws in formal ways. There's no entrenched acts. And that has then sovereignty of parliament. That's maybe what is the most relevant for this course when we talk about judicial review, is also the idea that basically no judicial body or other body could nullify an act of parliament or refuse to apply it, or declare it, treat it as void or unconstitutional. You can see that's a very different system, for example, from Germany or from also the US, where very soon Marbury versus Madison, the US Supreme Court basically said, well, because the Constitution is superior to ordinary law, well, the court is here to enforce the respect of the Constitution. Maybe just one comment. I can ask you, most questions at the exam are about the case law, but you can have a question on sovereignty of parliament. So don't dismiss it just as kind of decoration. I'm telling you this because I've noticed sometimes students think, well, that's a bit of decoration, and if they are asked the question, they are a bit, oh, help. So I'm giving you the help before the exam, not during the exam.
Can I ask a question?
Yes?
Judge an act of parliament as unconstitutional. What are they doing?
Well, there's acts below parliamentary acts. There's decisions. You can always, you can check if the decisions are in conformity with acts of parliament, etc. And also what courts will do, and it's quite a relevant question also for Swiss students. I mean, we have something similar. Our Supreme Court can't refuse to apply acts of parliament which are against the Constitution. They have evolved. They now basically set aside acts of the Swiss Parliament which breach the European Convention. But this is a clause in our Constitution that has been resistant to change. Every 10 years, it's kind of, there will be a proposal, we should introduce constitutional review, and we go to Parliament as experts and say maybe it would be, not all of them, but I generally go there saying it would be a good idea, and nothing ever happens. So. And we'll see also what will a court usually do, will also try and solve a problem with consistent interpretation. But even that was quite limited in the UK. We'll see it in a second. And maybe just also, I mentioned the Supreme Court, which is now the highest judicial body in the United Kingdom. So a recent institution, I said before it was the House of Lords, which was in charge. And you can see also when we look at the competences that, for example, an important, what does this court do? For example, look at devolution issues. If there's a disagreement, who is competent? Is it like the Scottish Parliament, or would it be, would it be Westminster? Limited constitutional jurisdiction as regards acts of parliament. We will return to that because we have the standard, this parliamentary sovereignty, which then was also taken into account in the Human Rights Act, but the Human Rights Act does reinforce the role of the court. You have here also a system when you look at the appointment on proposition, I think, by a special commission and life tenure. And maybe then also what was the role? Here I'm placing myself also in the standard common law system before the Human Rights Act. How were rights protected in this common law system? One approach was basically to say we are in a way a liberal legal order, so we will presume if something is not prohibited, you are free to do it. This is what you call the residual rights theory. So you are free to act within the law, but you can certainly see the limitations of that. What do you do if the law actually encroaches on your freedom? There were also some rights recognized by the common law, for example, natural justice, procedural rights, etc. But there were difficulties. How do you comply with the European Convention? Because the European Court of Human Rights is here to make sure that the convention is respected, and it doesn't matter where the source of the violation of the convention comes from. It doesn't matter, is it an act of parliament, is it a decision by a lower court, is it something based on secondary legislation. And I notice it's quite interesting also in Switzerland, sometimes hard to explain. That I will hear, but this is an act of our parliament, and it was approved by the people in a referendum. How can Strasbourg say something else? Well, that's Strasbourg's mandate. The whole domestic legal order has to comply with the convention. So the difficulty was for the United Kingdom that Parliament sometimes would not be able to solve an issue. Would have to say, well, that's an act of Parliament, and then people would go to Strasbourg, and Strasbourg would find otherwise. So that was a major motivation also to adopt this Human Rights Act, which we will look at in a second. So I said before, usually courts will resort to consistent interpretation. Say, okay, if an act of Parliament breaches, the European Convention, or in Switzerland, the Constitution, will try and solve this through interpretation. And you can be sometimes quite creative through interpretation. But basically in the UK, before the Human Rights Act, judges would say, well, we can solve the issue through consistent interpretation, but only if words of Parliament are ambiguous. So if they seem very clear, well, then it would be dangerous for a court to step in. That's against sovereignty of Parliament. And also, I must say, when I first read this case, I thought it was a bit counterintuitive from a Swiss perspective. The question was, maybe I'll first say what it was about, was what about secondary legislation? So you have an act of Parliament which grants power to a minister to adopt some secondary legislation. Then you could have assumed that there's not much of a problem to say this secondary legislation has to be interpreted in the light of basically of the European Convention. You could say Parliament doesn't want to delegate the minister the power to violate the convention, but this is not what the case law said. Basically, the case law before the Human Rights Act would assume that that basically Parliament, you can't impute to Parliament this idea that it delegated power to the minister and that the minister would have to respect the European Convention. And what was the consequence of that? Basically, courts would step in, but only when they felt that the minister's action were unreasonable. There was a principle from a case named Wensbury. So basically, you will check secondary legislation and action of it's administrative review also, but it has to be unreasonable. What does it mean, unreasonable? Unreasonable is not the same as proportionality. And before the Human Rights Act, there was a lot of discussion. Would proportionality review be something different than Wensbury unreasonableness? And the answer was yes. And why is the answer yes? Is when you look at the definition of unreasonableness. Sometimes courts mention this irrationality test, something so unreasonable that no reasonable authority could ever have come to it. So it's kind of you've taken leave of your senses. Outrageous in its defiance to logic and accepted moral standards. Improper motive. So basically, also for secondary legislation, the review was really not strict. was very deferential. And what was the idea behind was basically to say, yes, Parliament's intention was to delegate the power to the minister, but obviously if they act totally unreasonable, that was unforeseeable for Parliament. Parliament, then it's in a way an abuse of the power the body was granted by Parliament. So just to sum it up, you can see that there was a problem with respect already at acts of Parliament. You can save them through interpretation, but terms need to be ambiguous. With secondary legislation, and that made the gap really quite big with respect to the convention, even secondary legislation, judicial review was not very demanding. You would need really to demonstrate that it's irrational, and that burden is extremely high, very hard. It's probably like in Swiss law, something is arbitrary. You wouldn't have thought of it. So against that background, then the UK adopted the Human Rights Act, which you have in your second reader. So I suggest have a look at the main clauses. Also, what was the UK is a dualist legal system. So when they ratify a treaty, it's not part of domestic law. So the European Convention before was not part of UK domestic law. So the Human Rights Act, first of all, is also to incorporate the European Convention, that the provisions are part of UK law. But at the same time, they did take into account parliamentary sovereignty. So it's not, I would say, a revolution, but it's an evolution versus stricter review. When you look at the Act, so first, Article 1 will basically say which rights have been incorporated. It will, all the substantive rights of the Convention have been incorporated, with some rights, with a safeguard also for rights under the common law, which still exist. It is said that freedom of expression and religion deserve special attention. But what is interesting, they excluded Article 13. Article 13 is the right to an effective remedy. So the idea of the European Convention is that if someone has a credible claim that a convention right was breached, you need to have a remedy domestically. What is the idea behind? You don't want everyone going straight away to Strasbourg. And why did they not incorporate the right to an effective remedy? Which makes sense to say, well, domestically you should first be able to complain about a violation. Has anyone got an idea? A hunch? It's not a coincidence. Basically, it is that the Human Rights Act, the system the Act installed, is not entirely compatible with Article 13, because you could still say that when an Act of Parliament breaches the European Convention, that the remedy is not always effective. I will return to that in a second. Then the Human Rights Act, first of all, says that when you interpret the European Convention, or bodies interpret the European Convention, they have to take into account the case law of the European Court. So here the idea of consistent interpretation has also been strengthened, and also it is made clear you need to take, it's not just the provisions of the European Convention, also the case law is to be taken into account. Article 3, consistent interpretation, again, interpret the legislation, but you see as far as possible in a way compatible with the European Convention. It doesn't mention ambiguous wording. It says something else, talks about as far as possible. So the idea being sometimes it's not possible to save an act through interpretation. What would a court do what can a court do in such a case? Basically, and this is why the Human Rights Act is not an effective remedy, it can only render a declaratory judgment. It's what you call a declaration of incompatibility. So the highest court can say, here we find the Act of Parliament is incompatible with the European Convention. And what is the consequence? Well, the idea is that basically it's up to Parliament then to solve the issue, amend the law. There is one case which illustrates still the maybe tensions with Strasbourg. Relatively, now it's not such a recent case, but it was about the UK had adopted anti-terrorism legislation, and basically that legislation enabled the detention of foreigners suspected of terrorism without trial for an indefinite period of time. And you can see the problem. So if you're a domestic, a person accused of being a terrorist, you will not be detained. If you're a foreigner, you can be detained. The UK, the Parliament derogated from the convention, and the House of Lords already said this is incompatible with the convention. But what happened to the people who were detained? They could not be released because it's basically the legal framework is still in place, and the court can only declare it's incompatible. So what did the people do? They went to Strasbourg, obviously, and the European Court of Human Rights basically said, well, like the House of Lords, we find there's a violation. So you can see there it's not an effective remedy on that level. Also, who is bound by the Human Rights Act? It says public authorities. There's an exception. What could that exception be? Lucky guess again. If you're in the logic. Anyone? No? Parliament. So Parliament is not bound, and the idea being that when the court finds that there is a violation of the convention, there is a faster procedure how you can change the laws to make them compatible with the convention, because you know that the ordinary legislative process can take very long. So this whole system is sometimes declared as weak judicial review, weak in as much as there is still quite some deference to Parliament. It's up to Parliament to solve this issue. Then also a logic of the Human Rights Act is to say we should as much as possible, if Parliament can't be bound, but ensure that Parliament will not legislate against the convention. And there's different mechanisms to do that. Basically, if you look at Article 19, it's really this idea of preventive control. Make sure that there is robust control in Parliament. First of all, the minister who proposes the law has to say, is the law I'm proposing compatible or not with the European Convention? So they will come with a statement of compatibility or say it's incompatible. So that means there is already raised awareness if there is incompatibility. And there's also a joint committee of both houses of Parliament which will review legislation and often suggest amendments, etc. So the idea being, let's make sure that Parliament does not, breach human rights. So important that basically, even with the Human Rights Act, it's certainly strengthened judicial review, but it's still the last word is with Parliament. It's up to Parliament. If an act of Parliament is against the convention to basically solve this issue. But there's no deference anymore to secondary legislation. So there was a change from this irrationality test I mentioned to proportionality review. Now, I would like to return to the case law. I gave you one case today to look at, which can be linked also to this issue of subversive speech, a case decided within the Terrorism Act. And you may have seen the facts. So it's to people participating in a demonstration about the Kurdish people. They waved the PKK flag, and the PKK is considered a terrorist organization in the UK. So they basically are prosecuted under the Terrorism Act. Did anyone see what was the offense? Anyone?
They had a PKK flag at the rally.
But in terms of the provision which was applied, what? So that was one legal issue. Basically, you have different, if you look at the Terrorism Act, you have, first of all, Article 11. If you're a member of such an organization, that's an offense. If you basically support such an organization with money and other things, that is an offense. And then you have Article 13. So it's an offense when you wear an item of clothing or display an article, that would be a flag, and then says the law in such a way or in such circumstances as to arouse reasonable suspicion that this person is a member or supporter of a proscribed organization. And the question then was to say, there was this discussion, do you need to prove there was an intent to promote, terrorism or so? Or is it sufficient? It's basically you don't need that specific intent. It's strict liability. That was one question raised. The other question raised was, or it was also examined within the compatibility with the European Convention. And maybe we can do a little bit of brainstorming. If you look at the outcome and the reasoning, do you see, if you compare it to Brandenburg versus Ohio, do you see differences? Or is it in a way an application of Brandenburg? The court does? So you're saying this case is not anywhere close to Brandenburg, and you also recalled, I think, the central elements which makes Brandenburg a very demanding standard. You said there's intent required. Remember the definition, it has to be directed at inciting imminent lawless action, directed at, it's the intent you have. And there's also the imminence requirement. There is nothing like that when you look at the court's reasoning. I think the court even says it's not about imminence. You don't need an immediate reaction. I will just try and find the provision for you. Oops. If you look, it's paragraph 77 on page 112. They say basically this provision, it's about a restriction or deterrence designed to avoid violence, not the prevention of a situation in which there is an immediate threat of violence and disorder. Paragraph 77, it's about line 4 and 5, where you say that where it is said it is not about immediate threat of violence or disorder. So that's clearly different if you understand imminence as closeness in time. It's not the same as Brandenburg. So here we can see one difference. The other one, what about this strict liability? What did the court say about that? That was one main argument, Broad, saying, well, it just goes too far to that people get sentenced on the criminal offense without establishing that they had an intent to what did the court say? Was intent required, not required? Why was? Sorry? No need, and why not? How do they justify that?
Because it already has like a reasonable suspicion of creating this support for the group.
Or put differently, no, I think you're not wrong. I think what you're saying is that they look at the effect. So it's as if in Brandenburg you would only say that's the second product in Brandenburg, it's likely to produce. So they say Parliament was concerned about the effect. They didn't care what people really wanted. And it's this, basically you have to look at it from the, almost an outside observer and say, will that person think that, they want to, what does it, suspicion of, arouse suspicion of?
Suspicion of supporting the group.
So they basically say, well, we will check, is there this suspicion or not? So you can see, again, there's intent is not required, so it's not the same as Brandenburg. Okay. What were the other reasons the court gave why they don't insist on strict liability? Why they don't insist on intent and accept strict liability? Maybe also linked to proportionality. What did they say in the proportionality assessment?
They say that, so Article 12, which is about, like, if you are actually part of a terrorist group, that has much, much stricter penalties. And so they're saying Article 13 is much more proportional to, we have, yes, a much lower standard of what's required, but that's fine. We found that this is proportional. And actually, the thing that we're trying to prevent is the effect that you waving that flag or having the symbol will have on everyone around you. Like, what we're wanting to regulate is what's happening in the public square. And so, therefore, that's the thing that we're trying to change. And your intent is irrelevant to that, so it's fine.
So you've summarized it really well. You would like to add something?
No, I think they also talked about how the law is clear. So if there was intent or not, it was the PKK was prescribed as a terrorist organization. So because it was prescribed, there was already all the information they need to know to commit that.
So when we look at it, because they examine it in the light of the European Convention, you will have the first requirement. It has to be prescribed by law, and the law has to be reasonably foreseeable. So this is what you're pointing out. They said it's clear enough that the PKK here will be, there will be a ban on this. And then in proportionality, this is always, courts will always, depending on what outcome they want to reach. If you want to say it's proportionate, you will say, look, it's not as bad. We make a distinction within the law. These, for example, had it been the more stricter offenses, Article 11 or 12, as a refugee, you could be kicked out. That goes really far. Remember, we also looked at the French Conseil Constitutionnel, which did not look at the sanctions at all. That was not at all taken into account in proportionality. If I were to defend these two people, what would I say about the severity of the sanction? Counter-argument. The severity, can you imagine a counter-argument? Or, they say it's not too bad. Look, there's something stricter in the law. If you defend these people, you will say, yes, but what? Or maybe.
For everyone to see, but for a larger group, so the law itself could be inconsistent.
So you say it's not so, it could be, and there were cases like that in Switzerland where someone had a neo-Nazi or some, flag and it's seen from outside a window and so what does display mean? Should we take maybe the context into account? But I think our counter-argument is that it's still a criminal offense. Wasn't it up to 6 months in prison? It's not necessarily, it's still important. And there is a lot of case law from the European Court saying, well, criminal sanctions, that's always a strict interference. So I'm not saying which way you would need to decide. I'm just saying you could turn it around as well and say, well, had the court wanted to say it's a violation of free speech, you would have insisted on the fact that it's still a criminal sanction where you can go to prison. Then remember we looked at another, yes, I'll give you the...
I'm quite lost here because I remember in paragraph 61 we quote Perinsek versus Switzerland. So I don't know if necessity in here, so it's not demonstrated, so the restriction, I mean, on here must be like wider the interpretation, so we didn't found like necessity of the sanction that I was mentioning.
I think it's very interesting that you're referring to this paragraph.
61.
Yeah, 61. I have 70. Isn't Perinsek 74? Wait. Okay. Yeah. They bring back Perinček in paragraph 74. And I think it's quite interesting because they say in a way, well, that there is not basically the Strasbourg court will admit restrictions even if it's not just about incitement to violence, etc. And then they look at Strasbourg's case law, they quote Perinček, and what does Perinček say? Perinček in a way says you have to look in a way at different factors. What is the political social background? How was it said? What is the potential that there will be some damage, some effective problem? It's in a way a contextual approach, which we saw last week when we looked at the European Court of Human Rights approach, the Facebook, the Meta Oversight Board saying, well, we check what the context is. We saw that the contextual analysis can be done more or less strictly. We saw, for example, the case of Leroy versus France, where, well, it was after 9/11, so it creates a risk. The question is here, do they do any contextual analysis? Do they say, we check what is the risk at this rally, that some people might get excited and there could be some consequences? Did you find anything like that in the case law? I would say no.
They didn't provide any context or made any context analysis. They just said, well, if there are people around, they might be incited to support that group. That's enough.
So it's in a way curious that they quote Perinček. Probably I would not have quoted it if I don't apply. They go a bit like, huh? You say you have to do this multifarious analysis. It's not done. But it's, as you say, it's basically the idea we just want to take away the oxygen from these groups. We will not do any special assessment. What is the risk in a concrete case? So again, you see a different approach. Basically, not really a contextual analysis, but you do have some proportionality elements through saying, well, we at least look at the penalty.
I think also because they say, well, if the government they've published a list of prescribed organisations, and so refers to the government who've made those decisions for a reason, and so any organisation which is on that list, doesn't matter what they do or what their background is, if it's an organisation on that list, then it's under the terrorism act. So it doesn't matter such how you get support for them or the level of severity of the organisation. If you agree with the designation, it's staying listed on that list.
And some scholars have called it a bit of a formalistic approach. Basically, you look at the organization on the list and then we won't discuss anymore. It is quite interesting that UK anti-terrorism legislation is being discussed also at the moment. You may have an idea of what context or...
Well, the Palestine Action Group, yeah, so it's the government's prescribed it as a prescribed organisation this year or last year, but then at the moment there's loads of peaceful demonstrations going on where and then people are being arrested under the Terrorism Act simply for holding signs saying I support Palestine Action, and there's all these things of there's videos of the police officers saying, oh, we have to do this under law, you're professing support for a prescribed organisation, but it's being a prescribed organisation, it's in the public list under the Terrorism Act, and every government has the power to call it a non-terrorist because people are being targeted under the Terrorism Act.
So basically, there is now criticism of saying this terrorism act is over-enforced. And if you go and you demonstrate for Free Palestine, it's kind of you supporting a terrorist organization. I have two sources here for you where you can read up on it. And it also ended up, apparently, quite a few demonstrators were older people. So now I found also interviews with grannies, 81-year-old, explaining why they went to demonstrate, and they ended up in police custody. So I'm signaling that human rights groups and have voiced concern, saying this is an over-enforcement, because as soon as you label someone as terrorists, you can really then clamp down on freedom of assembly quite strongly. So the case we have read for today, in a way, it is in a context of it, and this is about the legislation, which is controversial at the moment. And if someone had a question, yes, and then we'll have the break.
Just like to make a comparison, can
just that like the risk is so great that the measure taken can justify it, no matter the imminence, no matter the la mens rea all of that. So here we can consider that terrorism is so bad that imminence does not really matter.
I think I quite like you. I haven't thought about it. I like this comparison. I think it's a good argument to say it's such a huge risk. So whatever we have to, and it's more of an abstract approach. It's an abstract danger, and someone used this deprive of oxygen. We just don't want. There's quite a lot of also, if you're interested in this topic, what about wearing Nazi symbols, racist symbols? Can that be an offense per se? Does it matter on the context, etc.? It was quite debated in Switzerland because our Supreme Court at some point was about the Nazi salute. And so you had right-wing parties meeting on a mountain, central Switzerland, a historical place, and one of them basically made the Nazi salute. And our court basically said, well, as they were among each other, that's not in a way propaganda, because in a way you only talk to each other. So that then gave this distinction, well, do you have to each time to make sure, is there someone who is not part of the group? Do you know if you have 150 people up there that they are all Nazis? I don't know. But it was quite a debated issue. So, and then if you want to legislate, which signs do you ban? Is it the wearing of the sign as such? Does it matter on the context? But so it could be interesting research if anyone looks for some research papers on symbols. The UK has, and Austria also have legislation, and Germany a long-lasting ban, obviously. It's not surprising on Nazi symbols. We'll have a break, and we'll continue then with defamation after the...
Non, ça c'est les textes de loi, vous n'allez pas devoir les lire en soi, mais c'est les textes de loi dont vous allez avoir besoin pour l'examen. C'est en fait
je peux
souvent...
lire moi-même tranquillement, mais c'est pas assigné non.
Non, moi je vous dirais surtout de lire, parce qu'on parle de dispositions légales en cours. Je vous conseille d'aller lire les dispositions légales dont on parle en cours, surtout.
Donc en fait, il faut lire les deux livres entièrement.
Non, pas le texte de loi, vous n'avez pas besoin de le lire entièrement. Vous regardez...
Il faut avoir l'information.
Oui, mais surtout vous regardez, si en cours on a mentionné l'article 14 CEDH, allez lire l'article 14 CEDH, vous voyez. Vous n'avez pas besoin de lire l'entier de la Convention européenne.
Ah, c'est comme référence pour l'autre livre. Dans les cadres.
Votre livre et ce qu'on voit en classe. Oui, c'est ça. C'est un cours de comparaison légale. C'est un comparative human rights abuse qui parle de différents systèmes. Vous voyez?
Can I switch to French or... J'ai juste pas compris le concept de comment ça marche en Angleterre par rapport à la CEDH. C'est-à-dire que, imaginons que le Parlement il fait un truc qui est contre la CEDH, et le Parlement il décide de ne pas le changer. C'est quoi mon intérêt d'aller à Strasbourg après? C'est ça que j'ai pas compris en fait. Si le Parlement il décide que il va pas
Parce que si
approuver
vous
son
avez
acte.
un arrêt de la Cour, il est obligatoire. Et on constate une violation, probablement après ils doivent libérer les personnes. Ils doivent montrer au comité des ministres, ok, quelles sont les obligations, vous devez déjà mettre fin à la violation. Ça veut dire que si des personnes sont détenues alors qu'elles devraient être en liberté, vous devez les libérer.
Ok.
Donc vous voyez, c'est comme vous sautez une étape. Après, on va aussi demander, on va dire, mais qu'est-ce que vous allez faire? C'est pas juste d'effacer la violation dans le cas ici. Il faudra aussi payer probablement une compensation
Oui, j'allais dire,
financière.
mais financièrement, est-ce que ça peut valoir la peine si on gagne du coup ou pas?
Vous savez, en général, les frais d'avocat sont quand même élevés. Donc, ce n'est pas financièrement que vous allez sortir. Et de plus, c'est assez imprévisible combien la Cour va allouer. Mais vous devrez au fond vous lâcher. Et après, il faut revoir les lois. Donc, il y aura une pression de dire, écoutez, vous devez maintenant revoir cette législation. Qu'est-ce que vous avez fait? Donc, la balle revient au Parlement.
Je suis allé sur UDOC, il n'y a vraiment pas beaucoup de cas avec UK.
Vous trouvez...
Il y a beaucoup Turquie, il y a beaucoup Suisse, il y a beaucoup Grèce. Mais
C'est vrai que
UK, j'ai dû descendre beaucoup.
Il y en a des grands arrêts aussi, mais c'est vrai que ce n'est pas un pays qui produit en masse dans des condamnations. La Suisse est intéressante, je vais discuter avec le juge belge à la Cour qui a dit, mais au fond, comment vous arrivez chaque fois de produire ces cas qui finissent en grande chambre? On n'est pas non plus le pire des élèves, et vous regardez, on a eu Cliva Senior, mais il y a pas
Le problème, c'était surtout aussi l'absence de... Ah oui, c'est possible. Souvent, c'était en fait l'absence de décision sur le fond par le tribunal fédéral qui posait problème aussi.
Mais je pense que c'est aussi la grande chambre, c'est quand même des questions qui sont importantes. Donc on va dire c'est des graves, vous voyez. Et après, il y a plus de visibilité. Et après, la Suisse dit on nous épingle, nous. Peut-être on devrait être fiers de produire des cas intéressants. Neuling, per incheck. Pour vraiment regarder la proportion d'arrêt de grande chambre qu'on a eu.
Et CGS aussi.
CGS.
Ouais, c'est vrai. Dalat Pontus, je sais plus, c'était peut-être pas la grande chambre. Dalat Pontus.
Donc, Dalat, c'était une décision d'irrecevabilité.
Ah, c'était une décision. Ok.
Merci beaucoup. Thank you very much.
I'm sorry, I'm disrupting. I'm disrupting a private free speech class. I'm sorry, but it's a pleasure to see you're having a good time together. So we're changing topics. The idea really was with these subversive speech cases that you see quite different approaches, how these cases can be tackled from, I would say, one end of the spectrum saying basically we don't do any analysis, proportionality analysis at all. That was the French approach. To Brandenburg, which is extremely strict, and then contextual analysis, which can go a bit, be more abstract, more concrete. Then it's up to you, obviously, to decide which approach you think is more convincing. It's also about balancing at the end of the day these different interests. Now, defamatory speech, which is certainly a topic very relevant, will remain relevant. Here, basically, what we will do today, we will read, or we will get acquainted with the solution in the United States. But to understand this case, it's really a landmark case, New York Sullivan, you have read for today, decided in the context of the civil rights movement under the Warren Court, a very liberal court, supportive, of this whole process of desegregation. But to understand the case, you first need to know what was the starting point. So what was the traditional common law of defamation? And here I would like to show you that actually if you take the common law as it evolved, and it's not very free speech protective. And New York Times versus Sullivan stepped into what is said to constitutionalize the common law of defamation, to make it more free speech protective. And we will see next week that other jurisdictions were basically grappling with the same issue. Canada, should we basically constitutionalize, change the common law? If so, how should we do it? Should we import New York Times versus Sullivan? Should we do something else? But we will see what the other courts have done next week. Just first, the terminology issue. Defamation here is a general concept which encompasses both oral defamation and written defamation. When it's about oral defamation, it's also called slander. And in writing or via the media, libel. So we will often hear about libel laws. So it's important to know libel laws are about defamation. We're always in this problem. The idea of libel being as it has lasting effects, if something has been broadcast or written, it's worse than slander, if just saying something orally without something being recorded or so. If you look at the common law of defamation, so it's basically the idea you sue someone for defamation. What would you need to prove so that basically you would get some damages because your reputation has been tarnished? So basically, first of all, you have to show that actually there was defamatory content, that it did tarnish your reputation. That's the first element. So you would have to show basically that it has injured plaintiff's reputation or subjected him to hatred, contempt, or ridicule. And also these statements, that's typical of defamation, they have to be false. It's not the same as insults. Insults are more swear words, opinions. We saw Chaplinsky, look, you goddamn fascist. That's not really defamation. That was more labeled as a fighting word. That's not a statement of fact. Then that is relatively, I think most defamation laws will also require that you actually target plaintiff. So we need to know that if I sue, it was about me, okay? I'm identifiable. It doesn't necessarily mean you name me, but if you say, the professor teaching the comparative human rights class at Geneva University, would be of and concerning me. But what does it exclude is, for example, general, if you insult a group, that would not be defamation. The law professors at this faculty are bad quality or are boring. That's not the. So often concerning the plaintiff. And also the idea is that you communicate it to third parties. If it's just face-to-face, well, then it's not then it's maybe an insult, but it hasn't really tarnished the reputation. And last element, you can sometimes you have grounds of justification. Could anyone think of a ground of justification?
If the statements are true?
So that would be the standard defense, would be exactly, I can prove the statements were true. It was first presumed, you say something about my reputation, that it's false, you prove that it is true. Or you have special also grounds of defenses. For example, when you say something in parliament, usually you have strict immunity. What is important here, that when you look at this tort, so falsity is presumed. It would have to be the person who made the statements, that person has to prove that it's true. The burden of proof is on the speaker. And also, when you look at this, there is no fault requirement. It doesn't matter if you acted diligently, you could get something wrong when you are an investigative journalist, you checked your sources, etc. It turns out to be wrong. According to the common law, the traditional common law, there is no basically fault requirement. So that makes it then obviously not very free speech protective, because you might think, well, I might still have got it wrong, and it's a risk. So here we have I talked about the justification grounds. As you said, it's truth, one of them. Fair comment is basically when you express an opinion, which it will be said it's not really fact, it's an opinion. But it has to be fair, so you would still need to show, it's what the European Court also calls a value judgment. If you make a value judgment about someone, you should still somehow be shown that it is grounded on some reality. Okay. So that would be a defense, but if you have purely factual statements, you cannot rely on fair comment, because it's more about an opinion. It has to be clear, it's an opinion. But you should still be able to show that it's not totally groundless. Or we have privileges, I mentioned parliamentary immunity, for example. Now the question also is, imagine you are a media, you will say, well, if I get sued for defamation and should the plaintiff win, what will I have to pay? What do I risk? So here there's certainly a difference. If you compare it with, for example, Swiss law, the first factor, compensatory damages, it's if I can prove a loss. Okay, imagine you write on Facebook or whatever medium you're using that I plagiarized my thesis and I lose my job at the university. I could say I actually have a loss here, salary, etc. So that that's compensatory damages. But interesting, in the common law system and also in the US, you can also get what is called general damages. General damages are independent, basically, on me proving that I have an actual loss. I have compared it a little bit to what we have, like I would say the moral damage, tort moral, for example, in Switzerland. But the amounts tend to be much higher in the US. Swiss law is, for example, very known even, for all the tort moral, when you have even malpractice, people who have grave injuries for the rest of their lives. You may walk away with 100,000 francs or something like that. So for defamation or so, you will not get much. In the US, it can be quite high. And also there's basically these trials, or the trials are by a jury. So you don't know what the jury will decide. When you look at New York Times versus Sullivan, you had general damages, 500,000. You have to think that nowadays it would be much higher. I don't know, maybe 10 times higher. So it was a very substantial amount awarded by a jury. So that's obviously a risk as a newspaper. And then on top, you have punitive damages. I think you all heard about punitive damages. It's always, I never know if it's true or not, but people like to find these extreme cases. Someone put a cat in a microwave and got millions awarded. Well, the instructions didn't say you don't put cats in microwaves, etc. So But so we're not talking, I'm not talking here about punitive damages, okay? Those would come on top, but you have to prove actual malice. But the general damages already can be quite, I would say, can be very high. Then you will also have costs obviously related to the litigation. And this is also a difference, at least to Swiss law, that there is a contingent fee system in the United States. So the lawyer can take a share of the amount which you get awarded. So lawyers will sometimes, you get also these, again, it's caricature, ambulance chasers. There's an accident and lawyers behind saying, look, I'll defend you, we'll sue. Look, and if you lose, I don't take anything. It won't cost you anything. If we win, I will take a percentage. It's something which is generally not admitted under Swiss law. But it means also if I got defamed and I find a law firm which is willing to take the case, I may have no costs there. Well, okay. If I lose, I don't pay my lawyer, and if I win, the lawyer gets a share, but I still get something. So that will also incite basically a risk for the press. What happens when you lose? In Switzerland, for example, when you lose, you have to pay also part of the other party's lawyer's fees. It will never cover everything, but you don't have that system in the press, in the US. So as a newspaper, if you get sued and you have high lawyer's fees, and well, actually, the plaintiff loses, wasn't a defamation, you still end up with your high lawyer's fees. So that is a deterrent which is still there. There is also cost which can be linked to the system of discovery. Does anyone know what discovery is? It's about administering the truth. In the common law system, there is much more, I would say, the parties have the initiative of proving things, and the discovery will basically be, you say to the other party, you have to deliver all these documents and you have to transfer them. That can be a lot of work as well, if you have to transfer enormous amount of data. And then imagine you also have lawyers, maybe you will ask for data too, and then the clock ticks and the lawyer fees are expensive, etc. So the discovery process sometimes is used also strategically to make sure that the lawyer's cost of the other party go up. There has been debates basically about saying this whole system can discourage criticism, mainly also of powerful actors. If you have a lot of money, you can bring a lawsuit and make sure the other side shuts up. I have an example which is from the UK. It's not the US. I don't know if anyone heard about the McLibel lawsuit. I think there was a movie made about it, and it ended up with the European Court of Human Rights. It was basically Greenpeace activists in the UK, and they were handing out leaflets against McDonald's. And the leaflets had the standard grievances against the big corporation. You don't respect labor standards. You cause worldwide obesity. You cause deforestation, and so on. And McDonald's managed to infiltrate this local Greenpeace group by a detective or whatever, and then they sued two of these activists. One was out of work and the other one also. Basically, they had no money. So they asked for legal aid, saying because it was up to them to prove all these facts. So, but they didn't, and the UK court said, well, no, this is a defamation case, no legal aid. So they were basically defending themselves against the crew of lawyers of McDonald's, and the outcome was that they managed to prove some of their allegations, but not all, and they had to pay, I don't know, £40,000 each of damages. The case went to the European Court of Human Rights, and the European Court found a violation of freedom of expression, saying there is such an imbalance of power. At least you would have needed to give legal aid. And there is also a public interest in exposing, criticizing big corporate actors. But so it's a bit a caricatural case almost in the imbalance of, but this is what you would call a slap, that a big corporation or some other actor has the money, basically brings a lawsuit, sometimes knowing that they may be wrong, but when you have about business and human rights, it's often used to say, well, and also NGOs will be afraid, oh, we get sued if we criticize this or that corporation. So some basically jurisdictions now have anti-SLAPP laws, which will allow courts to say, well, here it is a public interest. We look at the case, we dismiss it. We don't want to enter. Canada has anti-SLAPP laws. So if you're interested, I wrote down here a case about anti-SLAPP legislation. So this is just to give you a bit of context that defamation law, it's basically a financial hazard, depending, and that will obviously be taken into account by media actors. Now, when we look at this seminal case, New York Times versus Sullivan, yes?
Sorry, I just wanted to ask a question about the libel case, because, sorry if I'm a bit confused, but I thought under the common law, libel cases can only be made against individual, not groups. So would a corporation...
The corporation sued. They sue against the Greenpeace activists, etc. Okay. Another interesting case is it was a film made about it. You know, The Denial? It's basically a university professor in the US who publishes a book, and she's a specialist on history and I think racism. And she mentions in her book, what's it called, Irwin, as basically criticizes one, it's a UK very well-known Holocaust denial person. And she calls him a racist. And then you see in the film she's jogging and gets a letter, so what is this? She gets sued in the UK. Why in the UK? Because in the US it would be more free speech protective, so she has to go to the UK and defend herself. And the common law means she has to prove, first, A, the Holocaust has happened, and B, because you have to prove that the other one is wrong, and that he has a racist motive. And there's the strategy of the lawyers. First, they think about bringing as witnesses people who were you lived the Holocaust, and they decide against it, saying we don't want to traumatize these people. But it means they have to read all these, conspiracy theories saying the opposite. And then how do they prove the racist intent? It's, here we're back to discovery, they take basically all the diaries. Irwin was writing diaries, 30 years diaries, and they go through it till they find racist statements. So if one evening you need a film to watch on defamation law, The Denial. I think Denial, with Rachel Weisz. So in the United States, at the time when Sullivan was brought, just to show that it was an important case, also legally speaking, remember low-value speech. If you look at Chaplinsky, you could have said, well, this is low-value speech. Slander is in there and libel. No free speech issue. This is not what the court does. The court basically steps in and says, well, actually, here it is a free speech issue. We can't just say it's low-value speech. Also, maybe one question, let's assume this is a free... Could you have seen another way how the court could have disposed of the case quite fast, applying the defamation law conditions? I think the court really wanted to hand down a judgment, which is a principled judgment. If you look at maybe I return here. Would you say maybe that one of these conditions was debatable? It's an ad about what, a political ad appearing in the New York Times. Yes?
The second element being about one person in specific, because the comments were addressed to the institution, police, not to the person being...
So I thank you, and that's really the answer I was looking for. You could have said it's a political ad, or you have the content in the case. It's about the police ringed the campus, police did this, and the libel laws were brought, and they were basically, it's also important, there were parallel libel laws in different jurisdictions. So it wasn't the only case the Times was facing, and by police officers saying, we're the head of the police, so if they criticize the police, they target us. The court could have said this is not about and concerning plaintiffs. They do say so at the end of the case. Only at the very end they say it would be quite disquieting if now you can't criticize government anymore. As soon as you say government has done something stupid, you say, you're criticizing the person in charge and it's libel. So clearly they dismissed that, but they didn't say just that. So I think they really saw the risk for the press and they felt, well, we should step in and do something because otherwise it's the viability of the press which is at issue. And maybe just that it was about the viability of the press. It's on page 116, the right-hand column at the bottom. They do raise the question whether or not a newspaper can survive a succession of such judgments. The wall of fear and timidity imposed upon those who would give a voice to public criticism is an atmosphere in which the First Amendment freedoms cannot survive. So it's always interesting to look at the context. What was the social, political context? And I think here the court really feels a succession of libel lawsuits like that will just basically ruin the press. So that's the background against which they decide New York Times versus Sullivan. Maybe one question, it's also when we look at, I will go back here, we have this ad, I heed their rising voices. Would you say when you read the ad and that it was really a shocking case of defamation, where you'd have said, this is really incredible, how could they dare to say that? I think the facts always play a bit of a role as well. To say, I can see people, what were the, yes?
I think from our current timeline or where we are right now, I would say that this seems not very strong voiced and not as urgent, but I imagine that during these times, I think it's in the 60s, it was very much stronger or had a more impact as it has now, because we see much more disinformation and much more cases like this that are therefore not considered as strong by this Canadian context of this time.
So you're saying it may depend also how maybe to us it doesn't seem very strong, it was stronger at the time. But I would say certainly the inaccuracies are not, that huge. And I got the impression, that's my impression, that it was a all-white jury. So they really tried to find everything which was inaccurate. I mean, who cares whether they sang Heed Their Rising Voices or they sang the national anthem? I mean, Martin Luther King was arrested not 7 times, just 4 times. Well, he was still arrested and they still tried to kill him, etc. So I think when you look at it, not the whole student body did this, but the police was on campus, they didn't ring campus. Okay. There were inaccuracies, but I don't find it a shocking defamation case or a shocking misinformation case.
Yeah, this is something that I realized by reading. I read it immediately after the first page. That it very much sounded like a legal wording or legal justification of racism. Very much so. It was just, well, there were like people posting something political. Let's stop that. Let's not.
The context clearly was desegregation, the South very much opposed. Juries composed of basically, in the South, you have a trial in a southern state with an all-white jury. I think that's the result you get. And it's always, dependent on context. I was also looking at, because New York Times is very free speech protective. I was wondering, you can see now kind of a lot of lawsuits being settled also. Trump bringing lawsuits against the press. Why do they settle? And one reason I found was to say, apart from all the costs you have, having to defend the litigation, that you don't know what the jury would do, in a southern state. That you will have a political influence and maybe a nice precedent, New York Times, but what will the juries do? So political context often matters. Now the question is, what actually did New York Times change? To what extent then did it make the common law more free speech protective? How did it change now and we're returning to the common law, these requirements? Anyone?
It basically flipped the person who has to prove whether the statement is true or false. So now instead of needing to prove that it's true what you said, it's the other way around. You have to prove like actual malice, and that it makes it way harder.
What is actual malice?
Actual malice. That you have intent or flagrant disregard of the truth as your or any search for the truth as you're publishing the statement.
So basically, when you look at these two requirements, what I put on there, falsity is presumed. I think New York Times doesn't make it so clear, but the subsequent case law is very clear. Now it's basically falsity is not presumed. It's the person who is sued. So if you write that I plagiarized my PhD, I would have to show that I didn't plagiarize my PhD. So basically, it's up on the plaintiff to show that the statements are wrong. So that's an important change. More came through more in the subsequent case law. And I also said that the traditional common law is independent on fault. And now they introduced this actual malice requirement. And this is really something you need to know what actual malice is. And basically it's called the New York Times privilege. So you basically would have to demonstrate, and I will show you, it's summarized a few times in the case. You have it already on page 113 in the syllabus, second paragraph. You have to show actual malice, that the statement was made with knowledge of its falsity or with reckless disregard of whether it was true or false. Same on page, it reappears on page 117, third paragraph on the left-hand side. And what is important, sometimes it's not, you don't have to show that the person, actual malice mean like you're nasty, mean. It doesn't mean you have a mean intent. So you do it because you want to harm the person. That's not, but it basically means you publish knowing it's wrong. So you're aware of the falsity, or a reckless disregard for the truth. But it's not simple negligence. I would say reckless disregard for the truth, it's something more like gross negligence. Then to show this is a very demanding standard. And what makes it demanding is also when you look on page 117, it's the second last paragraph on the left-hand side. So 117, left column, second last paragraph. There they talk about the standard of proof. Is it enough? It's not enough to say it's likely that the press knew. In the US or in civil law procedures, you would have usually a rule called preponderance of evidence. It was more likely that they knew than they didn't know. Here, it's a much stricter standard. They say you have to show clear and convincing evidence. Not so easy. How will you prove there's clear and convincing evidence they knew it was wrong? And moreover, it is basically considered a subjective standard. So also you look at almost at the state of mind of the person. And you never know what is in someone's state of mind. It's not an objectivized standard that you would say, what would a good journalist do? And from the perspective of a good journalist, not checking the sources is bad. And then when you look at the case law, often basically, there were even cases where someone made up an interview and it was not considered as actual malice, where you would say, well, if you invented, you should know that this was not true. So let's say it was really a very protective standard, saying very hard to prove there is actual malice. Some people might say it's almost like immunity. But then the question is, to what kind of defamation proceedings does it apply? When we read New York Times, yes?
criticism towards people of the government and other public figures of the press or something like that?
So it's true at the beginning it was limited. When you read New York Times, that you need to know that too, it's about public officials. It's not public figures, public officials, so people holding a public office, and it's about their official conduct. So what does that rule out? It's the private conduct. If you say, I don't know, the sheriff of Montgomery has a mistress somewhere, well, that would not be official conduct. So you can see that it is a strong privilege given, but at least in New York Times, still quite contained to public officials and official conduct. It was later expanded. I have that on other slides, and if you read the opinions here by two justices who want to overrule New York Times, you have also sensed that the privilege has expanded. But so basically, if you translate it into really something technical, New York Times will apply if it's a public official in that case, and official conduct, and then you have to show that the person acted with the speaker or the newspaper published with actual malice, meaning intention, knowing it's wrong, or with reckless disregard to the truth. High standard of proof, clear and convincing evidence, and it's a subjective state of mind always. So, for example, not checking your sources clearly is not enough. And you could see also here it wasn't with the Times as well. They said, well, even if you may not have checked everything in this ad, it's certainly not reckless disregard for the truth. A question arises, what's the justification of that rule? What does the Supreme Court tell us? It can't be to say we love misinformation, let's promote that, it's fun. That wasn't the justification.
People, and therefore the censorship should come from the people to the government, not the government
From the people.
So people should have a way of communicating about wrongdoings of the government, and therefore it's necessary to not restrict what the people can say.
So basically, you remember we discussed different values underlying freedom of expression. And this is really a case emphasizing democracy, saying in a democracy you have to be able to criticize those in government, and that is how a democracy works. And there was, I can't remember his name, a famous free speech scholar who, after New York Times versus Sullivan, said, this case makes me dance in the streets with joy. It's about democracy, etc. And so what about the idea, but we have nothing to gain from false statements? Why would we protect, these statements? Defamation is about false statements, or maybe...
Facts, the truth shall emerge during this discussion. So yeah, I think it emphasizes the arguments of Stuart Mill.
Do they really say about it will emerge, the truth from the... I'm just wondering if I don't have that in mind. But certainly it is about wanting a robust discussion. Say we should have a robust discussion in a democracy, because you could still argue that generally, defamation, people will say where there is smoke, there is a fire, it still causes. But you tell me if you have, maybe I missed something. Yes.
Well, and I think also this idea of if you make it so that it is impossible for the press to actually pursue any version of trying to find truth, like we have to accept that there will be a few errors in the press trying to report what's going on. But if you have defamation law that's so punitive that it forces the New York Times to say we're not going to cover the desegregation that's happening in the South because we're going to get sued every time we talk about anything that's happening there, then we're not actually creating a public square where we're talking about the thing.
So basically, this case is also famous for insisting on the chilling effect. So they do not say it's valuable to have wrong statements, but they say some wrong statements are the price to pay to have sufficient discussion. And they insist, this is also very famous in the case, they they talk about the page 115, a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Maybe it's that the passage you had in mind, talking about Mill. And then they also say, page 115, it's on the right-hand column in the middle, that erroneous statement is inevitable in a free debate, and we need to create, in a way of free speech, needs to have breathing space. Create like a safety valve, make sure people will still dare to speak up and not be afraid of excessive censorship. Then also quite typical, a historical argument that we have seen what the result is of, too restrictive approaches, the Sedition Act, etc. And then I think you have, it's on page 117, they talk about the risk of self-censorship. And they give the example, which explains it quite well, of a bookseller. If a bookseller is liable for, now imagine a law saying any obscene content, you could be sued, well, you can't read all the books. You might just specialize in children's books. There won't be anything obscene, preferably for the 1 to 2 year old with just elephants and little pictures, and it's cute, but not great for the freely accessing ideas, etc. So it's important, this chilling effect rationale. It's not to say we want to promote false statements. It's to say false statements might be the price to pay that we still have a robust democracy. Then maybe also just moving on, this approach of the court in New York Times has been described in the subsequent case, Goetz versus Welsh, basically as definitional balancing. And what is this idea? It's basically saying we take one category of cases. This is lawsuit, it's defamatory statements against public officials and official conduct, and there we have one rule. You can't recover unless you prove actual malice. It's virtually impossible. We will not look at each case at a time. Maybe there will be some defamation cases where you'd say, well, we have more sympathy with the plaintiff. It was worse. It was not just little errors. So, but it's basically saying we don't want to do that case by case. We look at it's definitional balancing, one category, defamation of certain people, and that's it. So we want to lay down broad rules of general application. This is what the New York Times standard would be. If you target a public official, it's official conduct, you have to prove that the statements are true, and moreover, it has to be proven that there is actual malice. New York Times then, I said at the time it was quite contained, it expanded. So there was a move away from public officials to public figures. Public figures are also, it's basically people who are famous. So you don't have to have any public office. It could be, I remember at the time, O.J. Simpson trial also. So that would be a public figure. And obviously, if you expand to public figure, it makes no sense to still keep this official conduct criteria, because it's not about public officials, it's about everyone. That means also New York Times now applies if it's about also private matters. Could imagine a politician having an affair and this is being talked about. And then there's different categories of public figure. The all-purpose public figures are people who basically everyone will know them. That was the difficulty in O.J. Simpson. How do we find people in the jury who don't have an opinion about the case already? But then there are limited purpose public figures. So people who basically might be known just in a certain sector of society, or who become a public figure because they are basically appear now in the media, they are drawn into a controversy. You have then the criticism of two conservative justices where they give an example. There was, for example, a woman who sued basically someone for saying, I have been sexually harassed. There's a lawsuit. It's in the media. And then it's basically the one who she has sued for sexual conduct, misconduct, who will say things about her which she considers is defamatory. Well, she has to prove New York Times because she's a public figure. Now the question is, I don't know, what do you think about New York Times? Would you have the two justices and in two conservative justices saying it should be abandoned? The context is very different nowadays. Would you agree, not agree?
It's complicated for me because normally Justice Thomas and I don't really see eye to eye on many things. But I think it raises this super interesting question of how do we combat the amount of misinformation and the entirely different media landscape that we have now. Of like, there was this very clear time in the 60s when we had New York Times versus Sullivan, where you have a few major media outlets, and if they're always going to be sued by people who are trying to silence them, we need to protect their ability to potentially make mistakes, to continue having a broad discussion. That's not what we have now. Anyone could be a public figure, basically, and as soon as you're on Instagram, you're a public figure. You know, there's no private conversations that exist anymore. Everything is being recorded, so it all could be libel. And so I think we need to, at the very least, have a real discussion about what is protected and how is the government supposed to get involved in deciding what is truth, what is misinformation, what is defamation. How can you somehow say you're just lying about me and there's nothing I can do?
So I think they show that the context is quite different nowadays, and also in a way that it's, you know, it might even discourage investigative journalism, because if you checked, you might know it's wrong. So basically, you might be better off just to publish and say, well, I didn't know it was wrong. So I think they have quite a few points. What comes through also that they're originalists. They will always talk about the original intent of the Constitution. The founding fathers didn't think that. Then I find it a bit incoherent to say, but nowadays times have changed. That's why we have to overrule New York Times versus Sullivan. As an originalist, you should be stuck in the 18th century. But I think some of the claims, it shows that it can be problematic, maybe in a very different context. But interesting, I was thinking now, maybe would you like New York Times overruled now in the US? And the press is very well aware of that. So basically, I found articles saying, well, thanks God we have New York Times now. You know, how would we...